Hi, I'm here with Steven Rees Davies, partner at Carey Olsen and a speaker of our tokenisation of real-world assets panel. Great to have you here, Steven.
Thanks very much, Ella.
So our first question, what can the UK learn from Bermuda's digital assets regime?
I think it's quite simple. Bermuda is one of the jurisdictions that regulated and gave legal and regulatory certainty to the digital asset market about a decade ago. The key is to understand the application of proportionality as a regulatory regime. The success, I think, of the digital asset regime in Bermuda has come about because, one, it's fully comprehensive. You can do almost anything in the digital asset world, including interest-bearing tokens, which in certain countries is banned, interest-bearing stablecoins. But it is regulated in a proportionate manner to the risk that you see. So we've taken Bermuda's historical reinsurance reputation for regulation, which is recognized equivalents in the US, the EU, and the UK. We've applied similar principles to regulate digital asset business. So observing what we've done, taking the best of it, and trying to apply that proportionality approach and allow innovation with the technology.
Very interesting. What legal issue is most often overlooked in tokenisation projects?
Good question. I would say it is the actual legal title of the underlying asset that people often miss.
Yeah.
They come to us with the idea of, I want to tokenize this real world asset, and I've chosen Bermuda or another jurisdiction out of which to tokenize because you can get credible regulation and licensing. Then if you dig deep and ask questions like, well, where is the real world asset? How is the real world asset actually or currently legally owned and controlled? And have they thought through the process of being able to reconcile between that and the digital asset they've actually issued? So the first question normally is it a native token or is it a non-native token? i.e., is the actual register of the actual underlying asset on-chain, or is it not? Is it off-chain and you're just simply acquiring it, a bit like a fund, and then issuing a token that represents some sort of financial interest or legal right to that underlying asset or a financial benefit of?
Great, lots to think about. What is the most important piece of advice you would give to companies or institutions entering or scaling in tokenized asset markets today?
I would make sure that your technology partner, or if you are the technology provider yourself, because many are, they're building technology for themselves to produce these products or offer these products and services, make sure you're looking at the compliance side. I think most natives have understood now that for the technology to be really adopted and get traction at sort of industry scale, they're going to have to make sure that the technology is compliance by design. In other words, the traditional financial world has turned around and recognized this technology is fantastic, but if you don't design it in a way that allows us to remain compliant, because our compliant rules in TradFi world aren't going away, then we can't use it. So, and I think you're seeing that with a lot of the big traditional financial players building their own blockchain solutions or engaging with technology companies who are saying, let us make the technology so that regulatory oversight and your monitoring and oversight responsibility with the issuer, if it's a token project, is actually compliant with the rules.
Great. And finally, what is the most significant development that has come out of Bermuda in the past few years?
I would say a world first is the sandbox that Bermuda introduced last year, which was about embedded regulation. This goes to that exact point, making sure that the technology itself is designed to facilitate and assist in compliance. What that sandbox did was allowing decentralized protocols, DAOs, decentralized autonomous organizations, and similar vaults and protocols to work with the Bermuda Monetary Authority as the financial regulator and understand and identify where the risks were and then where the persons are. And I say that because if you think about law and regulation, it's there to persuade or incentivize people with behavior, good or bad, prohibit the bad, promote the good. But that only applies to persons. And if you look at truly decentralized protocols, there is no person per se. They're effectively trying to be freestanding. And what you've got to do is look at, well, where is their touch point? Because you can't regulate an arrangement, but you can regulate the people behind it or in it or around it. Okay. So that's been the most exciting thing. And we've had some actual licensing occur this year that came out of that sandbox. So first decentralized derivatives platform was regulated by the BMA. So watch that space.
Very exciting.